welcome. Yes, it is Sunday, March 26th. No, it is not Monday, March 27th, but I thought we'd do something a little different. Um, Understanding that I am a big believer and proponent of adult education theory, I accept wholeheartedly that as adults, our brains think differently. We learn differently. We need different responses or different touches in order for our brains to respond with the growth that we want. And so we're going to do something a little bit different. Lots of places and a lot of people call this a reversed classroom. I just like to call it teaching. The concept of a reversed classroom was actually something that started decades ago in an elementary school in Colorado, I believe, where the teacher, realizing that there's just not enough time in the day to actually cover the materials that students needed, began to assign as homework, right? The study materials for the day that would be covered in advance. So, for instance, if we're going to have class on Tuesday, I would give you the homework assignment Monday for you to do Monday evening, and then we would come into class on Tuesday and talk about it. So, that's what we're going to do right here. We're going to do a reverse classroom. Here is the lecture. I will post the PowerPoint for the two cases that we're going to discuss in class tomorrow, March 27, 2023. My intent and my hope is by providing the lecture today, when we get to class tomorrow, we can take a deeper dive into what these doctrines really mean. We can talk about the social policy. We can discuss whether or not we agree or disagree. We can actually invite another layer of essence to the materials. So the lecture for Monday, March 27, 2023 is special duty rules. Let's get started. Special duty rules, special duty rules. We're going to discuss the duty to rescue or the duty to protect. We've hinted around this all semester without addressing it directly because we weren't there in that part of our journey, but we've now arrived to that part. What is the duty to rescue or to protect anyone? Do I have a duty to rescue you? Do you have a duty to rescue me? Do we have a duty to rescue anyone? Here's the general rule, and we know that oftentimes, especially in torts doctrine, we address a general rule, for instance, caveat emptor. But the focus for the study, the focus for the learning growth is really going to be the exceptions to the general rule, right? General rule. No one is required to rescue anyone. Seems harsh. Yeah. In fact, it seems so harsh, it requires contemplation. What do you think about it? Do you think that no one should be required to rescue anyone? Do you think that everyone should be required to attempt to rescue everyone? If it's not a all or nothing type of situation, and we should be required to rescue some people some of the time, what do those rules look like? What does that doctrine look like? What do the exceptions look like? What does social policy think about any or all of that? All right. Without having that discussion, which is what I hope to explore in class tomorrow, let's get to the nitty gritty and let's talk about the two exceptions to the general rule of no duty to rescue anyone that we're going to cover. So here are the two exceptions that we're going to cover. General rule, no duty to rescue anyone. Exceptions to the general rule, carriers, innkeepers, landowners, shopkeepers, example, casinos, because that's the case that we're going to go over, and The exception to the rule of no duty to rescue anyone is that of voluntary rescuers. Let's talk about Lundy v. Adamor of New York. Lundy v. Adamor of New York. Adamar, sorry. Lundy v. Adamar. Adamar is the owner of the casino. That's why the casino is called Trop World, but it's owned by Adamar of New York. Overview of the case. This is a case that illustrates an exception to the no duty to rescue general rule, right? The exceptions that we're going to look at in the Lundy case are two. Restatement of torts, section 314A, specifically paragraph 1B, and restatement second of torts, section 324. Ready? Let's go. What is the procedural history? Did something here a little bit colorful to get you excited? Maybe by showing you the different colors, you can look to see, oh, these are different touches. These are different touches. So how do we start? Plaintiff, Mr. and Mrs. Lundy, specifically Mr. Lundy, had a cardiac arrest at the defendant's casino. Casino provided medical care to the plaintiff. Plaintiff suffered some permanent damage. Plaintiff sued the casino. Casino moved for summary judgment. Trial court granted the motion for summary judgment in favor of the casino. Plaintiff appeals. Questions? Shouldn't be any questions. We've done this at least 20 times now, 30 times now. All right. What are the legal issues? What are the legal issues? Yeah, there's more than one. What are the legal issues? One, what duty of care does a shop owner, in this case, a casino, owe to rescue one of his patrons, an invitee, right? And did the duty of care that the casino owed to the plaintiff, assuming that there was one, go as far as to require the provision of all medical services that the plaintiff may need? Issue number two, did the nurse that's employed by the casino fail in the duty of care that she owed to the plaintiff, since she voluntarily offered to assist in his emergency? And you know from reading the case that she didn't voluntarily assist. However, this is a position that is put forth by the plaintiff. That's why I address it. Let me say it again. We know that the nurse, that's Nurse Slusher, who provided medical care as an employee of the casino to Mr. Lundy, was not acting voluntarily. But I address it here in the issue simply because Mr. Lundy asserted that if I can't get there this way, can I get there the other way? For grading purposes, I will give you all of the points if you did the duty of care to rescue, right? But if I'm going to give you all of the points for the primary issue being the duty of care to rescue, then I'm going to have to give at least 5 bonus points. I'm going to have to at least give 5 bonus points to the people who are really doing work, to the people who are really diving deep, to the people who are really being able to discern and decipher these nuances. So if you've got what is the duty of care that the casino owes to the Lundys, I'll give you 10 points for that as an issue. But if you got also this whole argument that's urged by the Lundys that if I can't get it that way, then I'm going to assert that the nurse was a volunteer and she breached her duty of care as a volunteer. If you got that, you get 5 extra points. Let's move on. What's the rule? Let's come back to the rule. Let's come back to the rule. All right, we're going to come back to the rule. What are the key facts? Key facts. Plaintiff, history of coronary disease, had a cardiac arrest, fell out at the casino, right? Key fact, we've got 3 people in the casino who are visitors, who are patrons, who are invitees that have medical experience, and they jump in to help. So within seconds, we've got Nurse Greenberg, we have Dr. Greenberg, we have an unidentified surgeon. Boom, they're on it, right? they're on vacation or honeymoon or whatever it is that they're doing, and they have this medical training and they run into the fire. They jump in, right? Immediately, right? Or simultaneously, or right, while everything is happening all at the same time, blackjack dealer sees what's going on, hits the emergency call button. We have two people that respond to the emergency call button. Number one, we have the sergeant of security, and the facts say that within 15 seconds, he's there or she's there. The sergeant of security is there. And then within that same 15 seconds, a security guard is there. We know that the security guard is female. Security guard gets on her walkie-talkie, says need emergency medical care, sends that to the command post of the casino, and within 2 minutes of that call out for emergency assistance, we get a licensed nurse who is employed by the casino, run down with an ambibag, oxygen, airway, but she doesn't bring an intubation kit. She does not bring an intubation kit. No problem. Key fact, we continue with the CPR, emergency EMTs, the emergency medical technicians eventually come. They're able to intubate Mr. Lundy. Mr. Lundy is saved, and we are here because Mr. Lundy survived. And Mr. Lundy is now suing the Deep Pockets because he says that the casino failed in their duty of care to him. Got it? Got it? That was a lot, but you've read it already, right? That's a lot, but you've read it already. And if you hadn't already read it, if you listened to this before class tomorrow, you would have read it, right? What's your process? You would have read it once to get the context, read it twice to get the rule of law with the required elements, right? Read it a third time to get the key facts, right? What's your process? What's your process? By the time fourth step comes around, we're ready to write an issue statement. Let's go back, legal issue. There are some statements. I did not write them as an underdoes win or a weather win, because that's what you're practicing. But I just kind of jumped to the nitty gritty because we've done a lot of underdoes win, weather win practice before. I jumped to the nitty gritty, identified the two issues, the one primary, which on this PowerPoint slide is orange, and the secondary one, which is just as important because it speaks directly to the second exception to the general rule of no duty to rescue anyone. Got it? Yeah? What's the rule? Here we go. Shopkeeper, i.e., casino, has a duty to provide reasonable medical care to its patrons in an emergency. Wait. You just said that there is a general rule that no one has a duty to anyone. Stop. Let's go back 2 steps. When we were talking about what duty does a landowner owe to a trespasser? None, unless we've got kids involved. Attractive nuisance is the exception. A licensee? Very, 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 very little. Remember the tree that got chopped down and the guy died because the tree fell on him? And an invitee. We said over and over and over again that the landowner owes the greatest duty to the invitee. Let's fast forward 2 steps. Let's come back to Lundy. What do we have? Shopkeeper, owner, landowner, casino owner, they stand in the same stead. So if the casino owes a duty to anyone, the highest duty that the casino owner is going to owe to whom? The invitee. So this idea that we have no duty to rescue anyone, there's an exception when we have a shopkeeper and an invitee, and it's an emergency. All right. What is the exception for an emergency? A shopkeeper has a duty to provide reasonable medical care, reasonable medical care, reasonable medical care to its patrons in an emergency. Got it? That's the rule. I have a sub 1 and a sub 2, which is further explanation of that rule. But the rule is a shopkeeper has a duty to provide reasonable medical care to his patrons in an emergency. What's the second rule that we need to address? A shopkeeper, like a volunteer of assistance, has a duty to not stop rendering that reasonable medical care and can be held liable if they stop providing that reasonable medical care before someone more qualified comes on to take over, or if by withdrawing, they put the patient or the patron in a worse condition. Got our rules? Did our key facts? Let's go to the holding. Got our rules? Did our key facts? Let's go to the holding. The appeals court in Lundy affirmed the trial court's grant of summary judgment on behalf of the defendant Cassino. Why? Okay, well, let's talk about the rationale, or in this case, let's look at the court's analysis so that we can understand why the appeals court did what they did. Here we go. The plaintiff asserted restatement second of torts 314A. The plaintiff asserted the restatement of the restatement of torts 314A. A common carrier is under a duty to his passengers to take reasonable action to protect them against reasonable risk. Okay, and really apply to ours. Let's go to B. That's 314A, parenthesis 1, parenthesis B, to give first aid after it knows or has reason to know that the patron is ill or injured, and to care for them until they can be cared for by others more qualified. The restatement goes on to say that an innkeeper is under the same duty, goes on to say that a possessor of land has the same duty. So essentially, what does the restatement of torts say? Section 315A1B. The restatement of torts, section 314A1B says, Cassino, you are accepted out of this general rule of no duty to rescue if the person that needs to be rescued is one of your patrons. You're accepted out of it. What does that mean? That means that you, in fact, do have a duty to provide what? Provide reasonable medical care to the injured party, assuming that you know that that party is ill, and assuming that you know that that medical care is required. So you do have a duty. You got to provide reasonable medical care. You provide that reasonable medical care, and to someone who has greater ability, greater expertise comes along. Yeah, makes sense? Okay. The plaintiffs here are saying under 314A1B, the Cassino had a duty to provide reasonable medical care and to continue to provide that reasonable medical care until someone more qualified came along. The plaintiff goes on here to say that the defendant, Cassino, failed in their duty to provide that reasonable medical care because, as the facts show us, nurse comes, she's employed, she's been a nurse for 15 years, she's an emergency room nurse, she knows how to handle emergencies, she comes running down within 2 minutes of the call, check, everything is great. She brings her stuff with her, everything except an intubation kit, right? So let's cut in directly into the throat. Let's get some air. Let's put a tube directly into the lungs, right? And let's get some oxygen in those lungs directly, which is going to better help oxygenate, which is going to better prevent the death of potential heart muscle, the death of potential brain cells, et cetera, et cetera, et cetera. Nurse says, we don't have an intubation kit, right? God would have it that the patrons that respond, one is an emergency room nurse or trauma nurse, one is a surgeon, and another one is another surgeon who didn't want to be identified because he wasn't looking for his 15 minutes of fame. Not to say that the other two were. But you've got the best people to respond in an emergency right there. One of the doctors, Dr. Greenberg, said, hey, nurse who's employed by the casino, give me an intubation kit, give me something sharp. I'm going to slit this soft spot right here. We're going to stick that intubation tube directly into the lung. We're going to pump some oxygen in there, and we're going to get this right. We're going to do this thing. We're going to do this thing until EMTs come, right? Nurses, I don't have an intubation kit. I am not trained. Number one, I'm not a doctor. I'm not trained to use an intubation kit. The policy of the casino is not to even have them on hand because I'm not trained to do that. Now, we have pieces that are required in an intubation kit. We've got a little bit of this, and we've got an intubation tube, and we've got a little bit of this, right? But I don't have a kit, right? Nurse didn't go get the pieces to make up the kit. The four of the people, the first responders, I guess, the three patrons and the nurse employed by the casino continue CPR, MPTs get there, or EMTs get there, EMTs have the intubation kit, they do it. Slit, tube, lungs, oxygen, bam, right? So if 314A1B says that the casino has a duty to provide reasonable medical care and to others get there. And if the casino, through their trained nurse, with the assistance of these other people, provide that reasonable medical care until the EMTs get there, what's the problem? Here's the problem. The Lundy said, I wouldn't have suffered the damage that I suffered that is now permanent had you, one, had an intubation kit. Two, when Dr. Greenberg asked you about the intubation kit and you said that you didn't have one, but you had the pieces of it, had you gone to get it, Dr. Greenberg could have intubated me before the EMTs got there, and I would have less permanent damage, if any permanent damage at all. Get it? That's what we're fighting about. We're not fighting about whether or not the restatement second of torts section 314A1B creates a duty for the casino. Absolutely. Absolutely. We're not arguing that the casino did not provide emergency medical services reasonably. Well, then what are we arguing about? We're arguing about that the casino did not provide all of the potentially available medical services. And the plaintiff is trying to say, had you provided all of the potential medical services that I needed, I wouldn't have permanent damage. The appeals court said all of the potential medical services are not required. What's required? Appropriate medical care provided until there's an arrival of qualified assistance, but appropriate medical care, also known as reasonable medical care, does not require providing all of the medical care. Got it? Yeah? All right. Yes? All right, let's go. Let's go to the second attempt of the Lundys to urge or argue or to establish that the defendant casino failed in their duty of care to Mr. Lundy. Let's go to the second attempt. That now gets us to the restatement second of torts, section 324A. Plaintiffs then argue, well, okay, well, let's set the scenario. If there was no duty to provide me with reasonable medical care, Mr. Lundy, and you got somebody jumping in, we're not talking about the volunteers. Why aren't we talking about the volunteers? We're looking for deep pockets. Who's the deep pockets? The casino, right? Well, now we got a couple of surgeons and they might be deep pockets, which might be the reason why the second surgeon's like, yeah, you're not getting my information. You're not getting ready to bring a malpractice lawsuit against me, right? So nevertheless, the Lundys have sued the casino. And so the Lundys have said, well, here's an alternate theory. Let's say there was no duty of care. And let's say by attending to me, the nurse that is employed by the casino jumps in and provides some medical assistance. In addition to that, let's say, because she has access to an intubation tube, which is part of a laryngoscope, right? She didn't bring it. She didn't go get it. So couldn't I then, Mr. Lundy, argue that you failed to provide reasonable care because you left me in a situation worse than I would have been in, right? The assertions are not founded in sound legal reasoning, right? Here's an example of a lawyer who sees the opportunity to sue a casino and says, I'll take your case. But the reality is the facts that are necessary to prove the legal theory aren't there, right? The facts just aren't there because we don't have a situation where the nurse of the casino is a volunteer. We don't have the situation where the nurse of the casino who is not a volunteer stops providing service, leaving the client or the person in greater danger, right? We just don't have that. And if you wanted to come at the nurse under the Restatement of Torts second, section 324, you have to then take into account that New Jersey had a Good Samaritan Act that says anyone in good faith who renders emergency aid to a victim shall not be liable for any civil damages as a result of acts or omissions by such person in rendering the emergency care. So even if the Lundys were able to try to get in somehow on this breach of duty for a volunteer who gives emergency services, they still have to overcome, well, but the Good Samaritan Act says, yeah, you're not going to sue those people, right? So after everything is said and done, the Lundys don't have a case. The trial court's grant of the motion for summary judgment in favor of the casino, who is the defendant, is affirmed by the appeals court. We walk away with an understanding of two rules of law. One, a shopkeeper has a duty to provide reasonable medical care to his patrons in an emergency. That requires reasonable medical care. That does not require all medical care, right? A shopkeeper, if they have someone who voluntarily renders assistance, because you don't have to unless you're under the Restatement of Torts 314A1B or even 314A 1A. A shopkeeper, if you have a volunteer who jumps in and decides to give care, even if I don't have a duty to give care, am now obligated to give reasonable medical care and to not stop providing that reasonable medical care until someone else more qualified takes over, understanding that if you stop providing reasonable medical care before then, and if the person that you're providing the medical care to now is worse off as a volunteer, you may have a problem unless there's a Good Samaritan law, right? And then you got to look at each jurisdiction to see what the Good Samaritan law says. That is Lundy v. Adamar of New York. Questions? Go back through the slides, get current on the slide. Questions? No questions. Let's continue with our special duty and get to the section of obligations to rescuers. Wait, obligations to rescuers? Is that a typo? Should that be obligations of rescuers? No, obligations to rescuers. So there's this idea that danger invites rescue. What is the duty of care owed to a rescuer, right, by the person who is placed in peril and needs the rescuer to come and save them? Huh? Wait. If I am camping on Mount Everest, because that's what I choose to do, I think it's fun, I'm an adrenaline junkie, and this is amazing. I'm going to post to my Twitter account that I don't have, and I'm going to post to my Instagram account that I don't have, and I'm going to show some TikToks on my TikTok account that I don't have. And so I'm going to live out loud on Mount Everest. And I put myself in harm's way, and I find myself in peril, in need of rescuing, and I can't rescue myself. If someone comes along to rescue me, are you saying that I might then owe a duty of care to the person who's coming to rescue me? Exactly what I'm saying. Wow. Okay. So let's talk about the rescue doctrine. What's the rescue doctrine? The rescue doctrine allows for the rescuer to receive recovery, to receive relief, to be able to sue, right? A person whose conduct created the situation from which they needed to be rescued to begin with. The rescue doctrine says, if I am a person who is in the profession or business of rescuing people, and I go in to rescue people, and by going in to rescue people, I find myself injured, I now have a cause of action against the people for whom I've gone in to rescue. That's the rescue doctrine, okay? Moody v. Delta Western is an example of what? Because what makes the laws as important as they are, oftentimes it's the exceptions, right? So Moody v. Delta is an exception to the rescue doctrine. Moody v. Delta is an exception to the rescue doctrine. We call it a firefighter's rule. Here we go. Here's the exception. Firefighter, police officers, right? First responders, but just these two specific first responders, firefighters and police officers, may not recover against a receiver of rescue services for the negligent conduct of the receiver. So in other words, if a firefighter or a law enforcement person goes in to rescue someone, the firefighter or the law enforcement person cannot now turn around and have standing in a cause of the action to sue the person that they've rescued. We call that the firefighter's rule The firefighters' rule is an exception to the rescue doctrine. Moody v. Delta, procedural history. Moody, who's the plaintiff, is an injured police officer who sued Delta Western for the negligence of a Delta Western driver. Delta Western sought a MSG, motion for summary judgment, under the firefighter rule. The trial court granted the motion for summary judgment in favor of the defendant, Delta Western, and the police officer, Moody, appeals. What's the issue? Simple. Not an under does win, not a whether win, but here's just a bullet issue. Does the firefighters rule apply in Alaska? Because this Moody v. Delta case is in Alaska, and we're looking at what that particular jurisdiction does as it relates to the rescue doctrine and the firefighters rule exception to the rescue doctrine. Key facts: Delta Western employee left the keys to a fuel truck in the ignition of the truck, right? So Western Delta is a company that provides fuel. In order to do that, they have to have fuel trucks. In order to do that, they have to have the fuel in the trucks. In order to do that, they have to have somebody who's going to drive the trucks that have the fuel. End of the day, driver leaves the keys in the ignition in the truck. Now, that probably was for efficiency. Whoever's going to be assigned the truck that day, the keys are already in the truck. You take the assignment, sign up here. You're taking truck number 1, 2, 3, 4. And then after that, sign back in, right? So Delta Western, because of some issues, came up with a policy that said, no more can you leave the key in the ignition. No more can you leave the keys in the ignition, right? Well, this employee, for whatever reason, left the keys in the ignition. A thief who's drunk came along, saw the keys in the ignition, and said, hey, I'm going to steal this truck. The inebriated thief stole the truck and is hauling down the highway with a truck that has 10,000 gallons of fuel in it. The guy, the thief driving the truck, is running people off the road. He is not only running people off the road, he's speeding in excess of 70 miles per hour, right? He's running into people. All kind of habit is being wreaked, yeah? The call comes out to the police that says, we've got this drunk driver who stole 10,000 gallons worth of fuel hauling down the road. And if we don't stop this, this is going to be catastrophic, right? So the chief of the police department happened to be riding in a van with another police officer. And they're like, hey, we might be able to intervene in this. So the driver of the van tries to get in front of the runaway. Oh my God, this sounds like a Hollywood movie. Tries to get in front of the runaway truck driven by the drunk thief. I'm assuming that the police who was driving the van think, if I get in front of him and hit my brakes, I can force him, the driver, the thief, to slow down. Thief ran over him, essentially. And as a result, the police chief suffered some damages, okay? Police chief turns around then and sues Delta Western for their negligence. Doesn't sue the thief, get it? Why don't I sue the thief? Thief probably doesn't have deep pockets. Who has deep pockets? Delta Western. I'm going to sue Delta Western for the negligence of their employee. Oh, do y'all feel it? Do y'all feel it? Do y'all feel respondeat superior? Do you feel it? Let's not get too excited. Not the call of the question. Hopefully all of this stuff is starting to, right? So regardless of what was happening in that situation, the police officer said, I'm going to sue Delta because it is the negligence of Delta, the employee of Delta, that created this situation from happening. Yeah. And so let's see what happens. The holding in the Moody case was to affirm the trial court's ruling of a motion for summary judgment in favor of Delta. Wow. Well, what's the rationale for that holding? Public policy. Public policy should not have to pay twice, or public policy states that the public should not have to pay twice for the same service. Well, wait a minute. What are you talking about? Firefighters and police officers are compensated. They're compensated through salaries. They're compensated through benefits packages. They're compensated. What are they compensated for? For rescuing and providing service to the public. Right. If a firefighter or police officer then gets to come back and sue you, a person, sue anyone, for providing the service for which they are compensated, then it appears from a public policy standpoint that the public is paying twice. I'm paying their salary, I'm giving you benefits, and now I'm open to liability for injuries that you've received in the course of the job that you've accepted, for which you are being paid and compensated for, right? And so because of that, the court says, yeah, this is a case where we have a firefighter rule exception. Usually under the rescue doctrine, we can have a rescuer, if they're injured trying to save someone, that rescuer may then have a cause of action to sue the person who was negligent, who got themselves in a situation to need to be rescued. But under the firefighter rule exception, that does not provide for a cause of action for law enforcement personnel if the injury is the result of their law enforcement duties, or for firefighter personnel if the injury is the result of their firefighter duties. So this situation, Police Officer Moody could not recover. The motion for summary judgment was granted and affirmed. That's the end of Moody. Here's a question. Because so many of our firefighters are volunteer firefighters, right? Rural counties, smaller cities, right, run by volunteer fire departments. Because those persons are not compensated and they're volunteer, would they be able to sue under the rescuer's doctrine? Interesting question. Well, that's all I have today, Sunday, March 26th, as we get prepared for class tomorrow using a process of adult learning theory that we call flipped classrooms. Let's see if we like it. I'll see you guys in the morning.